How do you know if the defense lawyer is going to trap you or try to trap you during your pretrial question and answer session known as a deposition in a medical malpractice case or an accident case or a wrongful death case? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The real answer is you won't know that they're trying to trap you. Now, what's the best way to avoid any sort of trap? The simple answer, the most basic simple answer is tell the truth. That is the best way you can avoid falling into any trap that the defense attorney might try and explode on you. That's the reality. Now, you might be saying, I don't understand. Okay, so let's go back for a second. This pretrial question and answer session, which lawyers call a deposition, is also known as an examination before trial. In these civil lawsuits, the other side, the people whom you have sued, their attorneys will have an opportunity to question you, the injured patient, the injured victim, at some point during the course of your lawsuit. And there are a number of reasons for that. The key reason is that they want to know from you exactly what happened in your own words. They want to know what medical care and treatment you received. And importantly, they will want to know how your injuries have affected you on a daily basis. What are you no longer able to do? What are you limited from doing? What can you do with pain or with certain restrictions? And this is an opportunity for the defense lawyers, the attorneys who represent the different people whom you have sued, to now learn exactly, in your own words, what happened to you, why this happened, and what problems you have now as a result of that. So now, as you are getting ready for your pretrial questioning, you are worried, you are concerned, you don't know what questions you're going to be asked. So you will meet with your attorney beforehand, and your attorney will prepare you for your deposition. Now, a lot of people have a misconception about what preparation for a deposition really is. Some people turn around and say, okay, I get it. Your lawyer is now going to tell me what to say in response to these questions. The reality is no, that's not what's going to happen. And in fact, that's not what works. That's not how it's done. Instead, when your attorney prepares you for this questioning, your attorney is going to go through with you the exact questions that you are going to be asked when the attorney sits down with you, the attorneys who represent the people whom you have sued, to now learn the details of what happened to you. Now, you might be wondering, how is it possible that your attorney knows exactly what questions are going to be asked? Well, that comes with experience. And any attorney worth their salt who has done this for a number of years will know exactly what questions the defense lawyers will be asking so that you, the injured patient, the injured victim, will have a clear understanding of exactly what it is that you are going to be asked. So now, a few moments ago, when I said the best way to avoid a trap is to simply tell the truth, that's the reality. If you start trying to exaggerate, if you start saying things that are simply not true, if you say things that are made up, now you are going to dig yourself a hole, many holes, and in all likelihood you will not be able to get out of those holes. Once you dig those holes, meaning once you answer those questions, that answer represents your sworn testimony, and it carries the same exact weight as if you are giving that answer in court, at trial, in front of a judge and in front of a jury. It just happens to be taking place a year or two before you ever get to trial. Now, you might be wondering, why is this done? Why does the defense have an opportunity to go ahead and ask you all these questions before you ever get to trial? The reason is because there's no trial by ambush. Now, what does that mean? It means when you get to trial, each side will know all the details of your case. Each side will have a clear understanding of what you claim. Each side will know exactly what injuries and problems you have. Each side will already have had an opportunity to question the other side's witnesses in your particular matter. Meaning, if it was a medical malpractice case, I will have had an opportunity to question all the various doctors who are involved in your case. And now each side will know exactly what the other has to say. Each side will know the reasoning about why certain things happened, as well as what your injuries are. So there is no trial by ambush, meaning everybody knows all the same facts. So how does telling the truth prevent you from getting into a trap? I'll tell you how. When you are questioned during your pretrial deposition, your examination before trial, the defense lawyer is going to ask you questions about the various treatments that you received, medical care that you received following your incident, whether it's a malpractice or an accident or something else that caused you harm and injury. And now, some of the things that they're going to ask you will be, hey, Mr. Jones, when you went to Dr. Gonzalez, what specific complaints did you have the first time you went to him? And did you tell the doctor about the history that you had? Did you tell the doctor that you had a history of X, Y, and Z? Did you tell him you were on the following medications? And now they will go through in detail what it is that you did at that doctor's visit. Now, why do they do that? Because they will already have the medical records in their hand. They will know the details of what you said and what you did during the course of that visit. Plus, they will also have had an opportunity to talk to their client, the doctor, who actually saw you during that visit. And now what they're looking for is to see if there are any contradictions. They are looking to see if you disclose all the pertinent information to allow the doctor to make an educated decision about what to do with you next. If you have failed to provide the doctor with certain information, or you exaggerated, or you omitted certain things, now that's going to be used against you. So don't think for a second that the defense attorney doesn't have all of your records. Don't think for a second when they ask you, hey, Mr. Jones, have you ever been convicted of a crime? And you turn around and say, they don't need to know that. Screw that. No, I haven't. Well, now what have you done? You've just dug a major hole for yourself if, in fact, you had been convicted of a crime in the past. You may have thought, hey, nobody needs to know this. It has nothing to do with this particular case. And you know what? You're absolutely right. It's got nothing whatsoever to do with that particular case. However, it has a lot to do with your credibility. And if you failed to disclose something like that, guess what? You will now have destroyed your credibility. Getting back to the title that I raised in this particular video, how do you avoid falling into a trap that the defense might be setting for you? The reality is that most of the time, these defense attorneys are not outwardly creating a trap, but they are looking for contradictions. They are looking to see what your memory was about particular events. Now, no one's going to fault you if you don't remember things that happened a year or 2 or 3 before, and that's perfectly acceptable. What they are looking for is for contradictions. Once you dig that hole and you go into it, now you've stepped into it, and it's unknown whether or not you're going to be able to successfully get out of that hole. So why do I share this quick information with you? I share it with you because it's a beautiful day here for a walk around the lake, and I thought this would help open your eyes and help you understand how these types of cases work in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.